Hello and welcome everyone to today's Fireside Chat. We'll be talking about offset bypass refunds. Some of you may know them as hardship refunds. First, we want to thank the American Bar Association and the Pro Bono and Tax Clinics Committee for sponsoring these Fireside Chats. And another big thank you to Janice Shee for organizing today's chat on OVRs. I'm Nancy Rosner. I'm an attorney with the Community Tax Law Project, LTCA, in Richmond, Virginia. I'm also a co-vice chair of the Pro Bono and Tax Clinics Committee. Joining me today, we have a great panel. We have Les Book, who's a professor of law at the Villanova Charles Widger School of Law. We have Maria L. Smith, who's the accounts technical advisor for the Taxpayer Advocate Service. And we have Shaheen Rahimi, senior attorney at Legal Aid Society of San Diego and LITC supervising attorney. So thank you again for joining us. Les, why don't you start us off with some procedural background and tell us what is an OVR exactly?
Sure. Thank you so much. And Nancy, it's a pleasure to be here. And in today's chat, as Nancy noted, I'm going to provide a little bit of background and context for understanding the offset bypass refund procedures. And it is a process that is not well understood by many practitioners, and I think even less so by the public. And I'll start with a brief anecdote. I'm involved with procedurally taxing, for a number of years. We've been blogging on procedural issues. And years ago, I had a conversation with TAS's Susan Morgenstern, who was suggesting some ideas for topics that we had not covered. And she suggested that we cover offset bypass refunds. And I teach procedure, and I've been co-authoring a tax procedure book for many years. And I have to admit that my understanding of the process was really not that thorough. Well, Keith Fogg wound up writing the blog post that Susan suggested back in 2015. And since our founding, the blog's founding in 2013, we've had well over 1 million visits and many thousands of blog posts. And to this day, our most viewed post is that post that Keith wrote on offset bypass refunds, with well over 30,000 unique visits and upwards of about 150 comments, most of which are from taxpayers who are struggling to understand what the process is. So it really speaks to the importance of offset bypass refunds and how understanding it can really help serve as a lifeline for taxpayers, especially those who are struggling. And in today's times, that's even more important. So I'll start with a little bit about background on offsets, because before we can understand what a bypass refund is, we need to understand the broader concept. And it's a concept that kind of relates to issues well beyond tax. And to understand, an offset really is an equitable right that allows parties who are mutual debtors and creditors to basically net out their debts. And even if those debts arise from distinct or separate transactions. And bringing it back to the Internal Revenue Code and the IRS, well, Section 6402 authorizes the IRS to refund overpayments to taxpayers. And people and practitioners often overlook the distinction between an overpayment and a refund. They're really separate concepts. An overpayment occurs when a tax module shows a credit balance, and a refund is what gets paid to the taxpayer. And so Section 6402A doesn't require the IRS to refund an overpayment, but instead it permits the IRS to set off the overpayment against other outstanding taxes owed by the taxpayer. And then on top of that, so that's a discretionary right that the IRS has. In Section 6402, there are other subprovisions which require the IRS to set off any remaining overpayments against some state and federal non-tax liabilities, like child support payments, if there is a proper request in from the third party, the benefiting entity. And so a refund is whatever the taxpayer gets after either the IRS exercises its discretion or obeys the statutory command regarding the disposition of the overpayment. So, okay, bring it back to offset bypass. And an offset bypass refund allows taxpayers to receive a refund when the IRS would otherwise apply its discretionary powers to apply an overpayment against past due tax liabilities. And as Maria is going to discuss in some detail, TAS case advocates are delegated authority to generate an offset bypass refund for a taxpayer if the taxpayer has no other debts subject to mandatory offset under 6402, and the taxpayer can appropriately establish that she is unable to pay reasonable living expenses if the IRS were to offset the overpayment against a past due tax debt. So it's a lifeline, right? And so that we could see how important that could be, especially when there's so many millions of taxpayers struggling and really depending and requiring or expecting to receive the overpayment in the form of a refund to meet their needs. So I just want to make one other kind of brief, kind of contextual tax procedure point to help set this up, which is, well, what happens if you don't get the OBR and the IRS applies the overpayment to a past due tax period? And this is another point where I'd seen confusion back when I was in my days as a clinic director. The application, or the IRS's application of the overpayment, essentially means that what otherwise had been a refund becomes a payment of that other period's tax liability. And once there was an application of the overpayment, then the taxpayer loses their interest in the overpayment as a refund for the year in which the overpayment arose. So, and again, this, when I was in the clinic, this frustrated our clients to no end. And I'm sure, for those of you who are in the trenches now, you experience that and live that day to day. So it gets us back to really the topic of today, which is how to avoid all of that. It gets us to kind of the nitty gritty of the OBR process. And with that, I'm going to turn it to Maria, who is really going to provide kind of a roadmap and kind of the ins and outs from how this looks from the IRS perspective.
Thank you. So one of the first things is regarding the OBR is, and you had mentioned it, Les, is that when can the IRS not bypass a debt? And that's in the case of the, if there's a state or non-federal, there's a federal non-tax debt. If those do exist, the IRS is mandated to offset to those things. So if the taxpayer has both a federal tax debt and the non-tax debt, the IRS will always apply the overpayment first towards that federal tax debt. Except the one exception that's happening this year is with the rebate credits from the stimulus payments and things. Those, in that case, the IRS will be bypassing the federal tax debt and still offsetting to those non-tax debts.
And Maria, can you offer some examples of non-tax debts that the refund would go to?
One of the largest one is child support, where there's past due amounts. So you could have a non-tax debt and have child support that's unpaid, but unless the agency has submitted the proper request to the IRS to stake a claim, then not necessarily will always be offset to there. Another one, large one, although there's been controversy on forgiveness of the debt, is past student loans, federal loans. Those are the two largest in particular, but it could be even if you owe taxes to the state and they file a claim, that's a non-federal tax debt, but it's still a debt there as far as offsetting to them as well.
So those are all situations where if the taxpayer has those debts in addition to the federal debt, it's going to be hard, if not impossible, to get the IRS to issue an OBR. So someone might want to try to clear up those issues first if they intend to request an offset bypass refund.
Exactly. If you know aware of a client having a non-tax debt like that, highly suggested contacting, either clearing up, if possible, make arrangements to pay some of these agencies where you have that past due. If you make a agreement to pay similar to with the IRS as far as an installment agreement, they may withdraw their claim to be able to allow possibly the OBR request to be allowed. If there's a disagreement or something like that, the agency can put holds in place until that issue is resolved. Always reach out to them. They're usually pretty much, if you can get in touch with them, considering the pandemic now, as far as contact, they're willing, like anybody else, to try to work with taxpayers in situations like to have hardship situations. So highly recommend contacting them first, work that out before requesting the offset bypass.
I'm going to go ahead and share the phone number for the Bureau of Fiscal Service, which I believe is who you would contact to find out if there are outstanding debts out there that may prevent you from being able to get your hardship refund.
Correct. They'd be the first place to call. They will be able to inform the taxpayer directly if there are any debts showing on the books, and to provide the agency name and possibly contact number to get directly to work with them.
So tell us a little bit more about the process. I don't know if you want to start with, like, who is a good candidate for an OVR?
A good candidate would be anybody who does have a past federal tax debt and is expecting a refund. The refund could be in the form of a current year tax return that's they're going to file or have filed, or it could be a past due tax return that hasn't been filed where they're expecting a refund from there, or even any type of adjustment credits, things like that. For instance, if taxpayer had a balance due for penalties and they paid them, and now they're coming in and requesting an abatement of the penalties, potentially there would be an overpayment then that would normally would be offset or applied to a past due tax amount. So a refund could be stemming from there that also could be there. If so, a good candidate in particular is a taxpayer who's in a hardship situation. Eviction notice, utility shut-off notices, a vehicle needing repairs to be able to transport back and forth to work, which essentially gives their major source of income. Basically anything that, like Les had mentioned, that's going to, if the overpayment had been offset, would it prevent them from meeting their basic living expenses. Situations like that. It's not necessary for everybody, because if they have enough money already, at hand to be able to meet those expenses, then they would not necessarily qualify for to bypass for the offset bypass of be able to receive the refund.
So how does the process work? I know that practitioners can do it and they don't necessarily need to involve TAS. Sort of in my clinic, as a rule of thumb, we usually try to get TAS involved because the timing is such an issue, and it is a complex process. So how does the process work?
Well, timing is crucial, but anybody in the IRS can issue an offset bypass refund. But like you mentioned, because of the timing issue, it's probably better to contact TAS directly in those situations. Particularly currently right now, normally you could call up the IRS customer service, get somebody on the phone. You could have all your ducks in a row and everything, but they're being pushed to move on to the next call because there's a lot of taxpayers who are, calling the IRS for assistance. TAS specifically has procedures for the situation and would be working the case. So they are the best first contact. As far as timing, it's crucial because the refund itself has to be issued prior to the offset date actually occurring. Normally it would be on the date, say for instance, a current year return being processed. Usually the dates happen, it's simultaneously. The return completes processing, the offset occurs. The one thing about IRS is that we can see usually at least a week in advance when that's going to happen. So we have ahead of time knowing that, hey, this is the overpayment, the offset's going to occur, and it's going to occur, if you're looking at it on a Monday, it's going to occur the following Monday. So they have that 5-day time frame to be able to issue that refund out manually, meaning using internal manual procedures to have that issued out. So it's a very short time frame. One of the things I recommend, if it's a current year return or even a past year return that you're going to be ready to file, is to make that contact with Taxpayer Advocate Service prior to filing it, to give a heads up. Hey, we have this client, they have a hardship situation. We have all this kinds of documentation to support that, and they have a past due debt. We're asking for an OVR, or to offset bypass refund. That way, when they're assigned a case advocate, the case advocate can advise them, okay, we're ready. Go ahead and electronically file the return, per se, is the best method right now, filing any documents if available. Go ahead and file it, and we'll monitor at this end to make sure from when it's being processed to when it actually shows on the system, so we can get that refund in right away.
So you're recommending wait to file until you've contacted TAS. Don't necessarily file and then contact TAS.
I do, but if that happens to be, because sometimes we all know, you all know, as working directly with clients, and sometimes they don't come the same day that they're ready to file the tax return. It could be, I filed my tax return yesterday and I know I have this past due debt. Is there anything we can do? So if in the case of electronically filing as quickly as possible, I'd say no more than 1 business day. Because electronic filing, the minutes it's accepted into the system, it's going through the system fairly quickly. Unless there's something that's either wrong with the return or being held for possible verification from the filters, as far as identity theft, or make sure the information, the wages and withholding and things like that are accurate. If something's a little off, it may delay the return, which may give a little leeway, but it's not something you want to count on either.
Right. So it sounds like there is hope if you've e-filed the return recently, but it might be better to wait till you've reached out to TAS to go ahead and e-file. But there are things that could slow up the return that may buy you a little bit of time if your taxpayer jumped the gun and went ahead and filed the return anyway.
Exactly.
So how do you define hardship? What kind of hardship documents, or I know you mentioned some situations, eviction notices, utility notices. And actually we have a question from our attendees. And it's something that we had discussed in preparing for this chat. In Virginia, there's a moratorium on evictions for non-payment of rent. And I experienced this recently in a case where we're trying to get an OVR for a client, and TAS is asking us for an eviction notice, but we can't get one. And I don't want our client to push for one. Is there a chance TAS can go around that, put a moratorium on requiring eviction notices, or what would you advise a practitioner in that situation?
Well, in all situations, first of all, for hardship, it's still within the same means as basic living expenses. So one of the best ways to be able to determine that, are they being able to meet their expenses, is the 433F as far as collection information statement. It breaks out nicely, various income sources, how much you're expecting doing on a per month basis, and expenses. We know that the 433F is used by collections to determine as far as collectability, or possibly releasing of a lien or a levy, various things like that. But the same information can be used if you're showing they're not meeting their basic living expenses. The same information can be used for in the case of an OVR as a reason. So in the case of eviction right now, where I think the majority of the states is moratorium, preventing eviction, And I know even prior to this, commonly in the northern states, that utility companies are not permitted to shut off, say, electricity or things like that, because in the winter, it's it needs for heating purposes. In the case of if there's children in the house. But even then, what happens when that moratorium lifts? They're still going to owe all the past rent and everything that they haven't been able to do. Is it all of a sudden they're going to be evicted immediately? When it lifts from this, we really don't know how it's going to work. So using that collection information statement to show, hey, we're not meeting the basic living expenses now. We don't have an eviction notice, but we're still not making ends meet without it, is a way to I'm not say bypass, but to document that hardship situation. Not necessarily, depending on the amount of money you're talking about, do you need all the supporting documents, bank accounts, pay stubs, things like that. Because much like collection, it depends on how much you owe, how much supporting documentation you need with that statement. But it does help to fill it out and to make that analysis, because it's something that TAS should be taking into consideration too as well. Like I
And
said,
then hopefully your advocate can tell you if there are supporting documents, what you might need. You might not need the whole gamut of bank statements and paychecks and everything, but it's possible. And hopefully your advocate would be able to advise you.
absolutely. They may ask for something in supporting, in lieu of that eviction notice. As far as, if they need something else to support it. Usually in most cases, they just go through the form itself to complete it with the information. Have, as far as numbers readily available, not necessarily does something have to be sent into TAS or to your case advocate, but just having that information gathered beforehand helps the process along faster.
Now, what if the taxpayer is having trouble getting any documentation together, but they are really struggling? What, if anything, can a TAS advocate do in that situation to try to help support them getting their OVR?
Well, TAS has one ability, unlike any other area within the IRS, is that they can take a statement. You can talk directly either with a local taxpayer advocate, and they can do a signed statement that verifies through telephone contact and everything that the situation exists. They'll write up a situation, as far as the numbers, possibly as far as the expenses, not be able to meet those needs and what's going on, and sign the statement and submit that in as well. And it's something TAS does not try to rely on heavily on just that document, but it could be used to support the other documents that we're able to submit in. That's the one good thing.
So that's great. So TAS has this other sort of tool that they can use to advocate for the taxpayer if the taxpayer doesn't have all of the documents they need, but they are in a really difficult, financial situation. And I think we've all dealt with taxpayers that don't keep really good documents, so that's a good option, but probably not one we should always expect TAS to do. I think when possible, we should come with the supporting documents. And so you mentioned car repairs. So are there other situations where, maybe not the straightforward utility shutoff notice or eviction notice? What other situations might someone want to consider that they might be eligible for an OVR?
Things that it's always existed, but you might come upon it now even more so with the pandemic, is that someone possibly living in a shelter, or they've already gone through the situation and they can't make ends meet, and now they're living with family or friends. And particularly with the pandemic going on, even more so with the shelter in place and stay at home orders and things like that, that it could be, it's getting very trying living in the same space with people day after day. And particularly if they're not members of your household, that could rub even harder. So absolutely, and that's something you really can't document unless for some reason you're getting that mail at that address, things like that. That's a situation that you will want to talk out and have the local taxpayer advocate if they can do a statement, signing this. And we're not just restricted to documents as well, is that in the case of a person living in the shelter, if they talk to the shelter, they can give permission to the local taxpayer advocate or their case advocate permission to speak with anybody else that can verbally support as well that situation. They could say, hey, the case advocate in particular could talk with the director at the shelter, and they may even want to do up a short letter to say that the name of the client and everything, there's a living situation that they've been residing at the shelter since the last 2 months or whatever, when it's expected, and they may even have agreement that, hey, you can stay here for so long, but after that period, you have to try to find ways to be able to live somewhere else or be able to get out on your own or things like that. Some do have counseling counselors at shelters to help those people to better themselves and get out of that situation. So something like that.
I think that answers a couple of the questions that we got in the chat about substantiating informal costs with the IRS. Like you said, you're maybe staying with a family member or a friend, and the hospitality is wearing out, and you're going to have to move out, or other informal agreements, a car sale. In those situations, I think that's a great option that you mentioned, that maybe Taz could actually speak to the involved person. But outside of that, would you require some sort of formal signed statement from the taxpayer? I guess what does Taz require if they're not getting the documents from the taxpayer?
Case advocates should be working as much as possible to come up with creative ways for this documentation, particularly now because it's very difficult to gain those access to that information, even with taxpayers. Work as much as possible, be creative. It may be something the case advocate might not think of, but your client, they have this particular documentation, this connection or whatever, where they are, that you may suggest, hey, can you speak with, we can give you permit, the client can give permission, or the taxpayer can give permission to speak with a particular third party. We would need that permission, first of all, before even talking with a third party, and the boundaries of that conversation to be just on the taxpayer's financial or situation there, not any of their tax information.
And is there a particular IRM provision that practitioners or taxpayers should look to, if maybe a case advocate is new or hasn't done that before and they're a little hesitant? Is there something that we can point to say, you do have the authority to do this, and it's supported by the IRM?
I do.
And sorry to put you on the spot for that. We can also pop that in the chat.
You will want to put it in the chat, because of course the information will be useful even in the future. So it's IRM 13.1.24.6.2.4, and that's the Taxpayer Advocate Service, IRM, and it's the title of the section is How to Advocate in an OVR Case.
Great. I'm going to drop that in the chat for those of you that weren't able to grab that.
And there's two others having to do with discussing unprocessed original or amended returns, or even in the case of it would be like a tax abatement or a penalty abatement type request. And those two sections are IRM 13.1.24.6.2.7. It's titled OVRs and Receipt of Unprocessed Original Tax Returns or Other Circumstances. And there's subsections below there as well, from 0.7, go a little further down to 0.2 is taxpayer sent original return to the IRS.
So just looking in that general area should hopefully provide some support for those situations. And I thought that was a great point that you made. And it was something that I hadn't thought about, that OVRs aren't limited to just current year return hardship situations. It could be an amended return. It could be a penalty abatement. So again, kind of forcing us to think outside the box. It's not limited to just the return processing, but really any situation where the taxpayer might be expecting a refund. But if they're in a pretty serious financial hardship, then an OVR could be a possibility, it sounds like.
Absolutely. There is one other place that mentions as far as the LTA signed statement being accepted, and that is in the accounting IRM. Okay, IRM 3.17, 0.79, 0.3, 0.16, and it's parens 5 and 6 as far as documentations that as a case advocate for TAS that's required to be attached to those refund requests when we send them to accounting to be processed. Documentation they're seeking that be attached, it's required to be attached, and both of those does mention hardship documentation or a signed statement from the local taxpayer advocate.
That's great to share. And I think Shaheen wanted to jump in here with some comments on working with the LTA.
Yeah, I mean, I just wanted to maybe preview some of the things that I'm going to talk about as practice pointers. You know, this is where the personal relationship that you have cultivated, hopefully with your local taxpayer advocate office, comes in handy, where you can really sort of push the levers forward based on your relationships that you've cultivated. This is where your personal relationship with the LTA in your city. This is where your knowledge of who the group managers are in that TAS office, because that's going to be critical. If you were trying to get that particular piece of evidence that's hard to come by, you got to have a good relationship with your LTA to provide that statement. So these kind of go hand in hand, especially when it's this type of a situation where timing is involved, complicated paperwork is involved. You really have to sort of do that background work already ahead of time. Have your ducks in a row. Sorry to interrupt, but that's kind of really dovetailing into what we're going to talk about a little bit later.
No, I think that's a great point. It is really important to develop that relationship with your local office so that you know who to go to, you know, maybe how they like to work, that sort of thing, but especially who to reach out to when you're in these really dire emergency situations. Because we know some of our clients, I mean, they're living in shelters, they don't have a penny to their name. And so things like the OVR as a possibility could really change their lives. And so, you know, I feel like as a practitioner, it puts a lot of pressure on us too, you know, to make sure that we do it right. So I think that's why this chat is so helpful. And it's so helpful to hear from Maria about how the process works on the TAS side to make sure that we're doing everything we can on our end to make sure that the process goes smoothly.
Absolutely. And one of those, that's part of the relationship with your local taxpayer advocate. Majority of you are all from LTCA clinics that as part of the program office is that reach out to the individual clinics and usually a visit, it used to be in the past, with the local LTA being involved with those visits. If a visit's going to occur either in person or even virtually using Zoom to participate to help build that relationship.
Right, but this is definitely something practitioners and taxpayers alike. It's a process that taxpayers can also do on their own through TAS and rely on TAS to get those refunds. And that's where maybe advertising, I know the IRS doesn't advertise OVRs, but as clinics, we can help to advertise that as an option for taxpayers, whether they qualify and can go through an LTCA or it's a situation where they may need to contact TAS directly.
Yeah, and I think, you know, just to quickly interrupt, I think that's one of the real challenges here. If you don't have that relationship with a clinic or you're unrepresented, there's just a huge information barrier for taxpayers to figure out what to do and how to do it. let alone the timing issues that Maria has identified. So it's a difficult process and difficult even when there's a practitioner, but I don't want to say impossible, but really challenging for many unrepresented taxpayers.
Most definitely. And like Nancy said, this is not something that's publicized by the IRS, and partly possibly because in some cases it's their only means to actually be able to collect past due taxes. So I don't think they're going to be willing to throw it out there that it does exist. So many individual taxpayers might not know it on their own. So, as a clinic in representing clients in the area to, notify them, possibly advertise, in a small way. There's a lot of businesses out there right now that, advertise already, do you have problems with the IRS? We can help you out type of thing. So why not as a clinic?
So Maria, are there any sort of last tips that you think it would be important for us to remember when requesting OVRs? I don't know if you want to touch on situations where the return was filed through a preparer and a paid preparer, and they're expecting to get their payment from the refund. What happens when the taxpayer then is bypassing the normal route that the refund would go?
Okay, so taxpayer, whether they file by paper or electronically, or particularly this year, everybody's using the at-home tax preparer software, whether it be online, that you can go online to a particular site to file your return electronically. In that situation, particularly when you're expecting a refund, which all these cases we're referring to, that service does charge a fee for their services, for providing that to you. And what they do is they deduct their particular fee that you agree upon when you're doing electronically return is deducted from the taxpayer's refund that they're expecting. So they'll get a little less of refund. The amount they're expecting is an overpayment minus the amount for the fee of using the service. That situation, that actually creates what's known as a refund anticipation loan or credit as far as that goes. And those situations, Taxpayer Advocate Service is one people that can still do a direct deposit to that account to honor that agreement. So the taxpayer doesn't have to worry about that part. Also, anybody in the IRS is not legally bound to that agreement either. That's between the client, the taxpayer, and the software provider. So the IRS is not bound by that. We can bypass that agreement as well. Is it in the best interest of the taxpayer? Not necessarily, because they'll still have that fee to pay to that software provider. But there may be situations that they need to bypass that. But TAS is the only one can do a direct deposit into that account to honor that agreement. There may be other situations where when they file their tax return, they put the incorrect bank account information in there. If the tax, that's one thing you want to verify with the client is you filed your return electronically, you put bank account information on there. Is this information right? Because if it's not, you don't want the IRS to be depositing that tax into that account. That would be a reason why to bypass that. And possibly if the taxpayer has their own bank account, then you'll want verification of that information, that bank information, to have it deposited into their own account instead then.
So it sounds like a good practice tip as you're going through the process to double check with your client what bank account they want to use, or do they want it issued by check, and if so, what address to use? Because it sounds like at TAS you have the ability and the discretion to direct the refund based on your own instructions and not necessarily what's listed on the tax return.
Absolutely, and it's TAS' responsibility, to find out what is the preference and the need. One thing is it depends on the taxpayer's need also. One thing to keep in mind, for that bank account is that if the tax return was filed as a single or head of household, then there's only one name. That name is the name on the account and the only name. If it's married filing jointly, the bank account must be in both taxpayers' names.
That's a great point. Okay, great. Well, thank you so much, Maria. Feel free to jump in if there's any other tips you want to offer from the TAS perspective, but I think now we're going to shift over to hear from Shaheen a little bit about, as a practitioner, maybe what his experience has been, what he's learned, maybe some tips that he might have for practitioners or taxpayers that are trying to go through the process.
Thank you, Nancy. Pleasure to be here, of course, with everybody. I feel like this is a small reunion of the LITC conference. When I look at the participants on the program, there's Bob Wonderdale, there's Caleb Smith, there's Nina Olson, there's Jocelyn Champagne. So glad to have everybody here. Yeah, certainly Nina brings up a good point in the chat about taxpayers who don't have representation, who don't have a LITC or even a relationship with their LTA, that's difficult for them as well. So absolutely, this is a very, very complicated, and the timing is critical. You know, we're going to talk about how you kind of got to get your ducks in a row. My favorite analogy this last week about making sure you have the documentation ready to go. Make sure you have your 911 to your local TAS office that you want to have assigned to the case set up. You have your relationship already sort of established with that TAS office to be able to coordinate everything. And so one of the things I wanted to show you, we've already sort of touched on it already. I'm just going to share my screen real quick to show you a TAS letter that I've received that talks about the Bureau of Fiscal Services. We just talked about this, and this is what happens when we've got the BFS side of things. As you see, this is my local TAS rep here in San Diego, Linda Ortiz, sent a letter to myself and to the client, and she reminds her, she says, hey, you also owe the BFS. You need to contact them directly at the number. We provided this already. Because, you know, while we can try to get that portion of your 19 refund once it's released, if there's a default debt with BFS, that's going to be an issue. So I wanted to show that real quick. That is some of the logistical sort of hurdles in your way sometimes. But certainly those three things are very important. You have to get your documentation ready. You have to line up the return itself and timing wise with the TAS rep and coordinate that. That's really the critical part here, to be able to make sure you have a successful OVR. And certainly, you know, even I learned just the other day when we were prepping for the meet that there is this potential to have the LTA put a statement together, where again, your relationship with the local TAS office comes in handy, especially now with COVID. I mean, obviously, I'm going to be somewhat Captain Obvious here, but paperwork is hard to get. It's difficult right now to be able to physically, logistically get some of those documents. You know, this particular client that I was showing you guys all the letter is a DV victim who stayed at a shelter. So you have to make sure you sort of get everything lined up. And even in this case that I'm telling you all about that is happening right now in my clinic here in San Diego, we weren't able to do everything correctly because her check went to the shelter where she's no longer at. So we had to try to kind of get that squared away. I obviously didn't want her to go back to that place that she sort of went to as a refuge place to kind of get away. But the logistics of it turned out that way. Her updated address hadn't gotten updated in the IRS system, and so the check went there. I think we talked about this in prep with Maria and Les and Nancy, that those are one of the things you want to get ahead of time, squared away, so that there's a bank account. Hopefully, she didn't have one, so it was really difficult to get that direct deposit somewhere. But we talked about this as well, that you want to make the functionality of this event happening as smooth as possible. Bank accounts got to be set up. TAS reps got to be set up. The returns got to be secured. All these things have to be done ahead of time. That's really the best way to handle it. And so that's really what you want to do. It takes some planning. It takes some preparation. You have to sort of get everything ready to go. So that's really what it takes. In my practice now for 15 years running the LITC, that's been the way it's come about. It's having a good relationship with your LTA, with your local TAS office. Very important to try to get that office, an advocate from that office assigned. So you want to facilitate that process of the actual physical 911 going in, having an advocate assigned, and then be able to work that with the local office. I didn't want to chat too much. I wanted to leave some questions available for folks, especially since there's so many LITC folks on the program. I'm sure they've got some sort of hurdles and obstacles that they've encountered. Maybe we can all share and figure out a way to get around those sort of obstacles. But that's basically what you've got to do: get your ducks in a row and try to get that process to be as smooth as possible.
I do want to interject and add on a little bit, is that one of the things to keep in mind, there is the potential situation, you've done everything, and for some reason, the OVR cannot be honored. As far as what to do then, you still have a client that has a problem, whether it's being your client or an individual taxpayer, whoever. From the tax standpoint, is that not only do we, from a tax standpoint, as far as working the case, not only do we want to get that refund out, but we also want to go back to what's causing the situation, that balance due. Is the balance due correct in the first place? Is it the result of an examination that, say for EITC, for earned income tax credit, where they haven't been able to show that the child actually lives with them? Or lived with them during the period, that year in question, for the sufficient time frame. Work that end of it too. It may be, in going through all that, gets totally reversed, and so that money that was offset there, in advocating for them to help resolve that sooner, may get that money back to them sooner as well. If it is a accurate balance due, and they're in that situation, have gone through and tried to set up some sort of a pay agreement, whether it be an installment agreement, or if they're still not meeting those basic living expenses, maybe it's something that needs to be marked as currently not collectible.
Yeah,
So,
I just one point to build on that, Maria, is that for practitioners, if there has been an application to that past due tax period, and again, as I mentioned briefly in the introduction, that changes the relationship between the taxpayer and that was purportedly an overpayment. It becomes a payment for that past year's liability. And then if the liability is not proper and the liability has been fully paid, then you have to be mindful of refund claim statutes of limitations. Or if it's not fully paid, it raises the possibility of an audit reconsideration and possible abatement of the unpaid assessment, and maybe the return or refund of the amount that's been applied if it's improper. So it triggers some duty of inquiry to see what's going on in that past year. And a lot of times, taxpayers may not really know or have the information. And so it might lead you to maybe get a power of attorney for that year to which the monies have been applied, so you can get some more information to properly advise your client.
Exactly. Don't just focus on the fact that you're trying to get the offset bypass refund, but focus on the entire situation, as far as why what they're trying to bypass in the first place. Whole picture.
I think that is an excellent point. And before we switch over to Les to talk a little bit about a recent ABA comment that we submitted regarding OVRs, I was hoping, Maria, that you could just talk briefly about the situation that we were seeing with the offset of the recovery rebate credit. I know now we're seeing it's supposed to be going to the taxpayers, but there was a period of time where refunds that included the recovery rebate credit were being offset to debts as they would normally. So is this something Taz can help with? How do you identify if that's happened to your client? What would you suggest in that situation?
Good one. The way it was written, it was that the EIPs themselves, 1, 2, and 3, were not supposed to be offset to a past debt. And it was supposed to go as well through to the recovery rebate credit as well. And there was programming at first that it wasn't happening, and someone thought it should be, and they changed the programming so that it did offset, and then it came back down that no, it's not supposed to offset, so they corrected the programming again. And you're right, there was a period, I think it was like 2 or 3 weeks worth of time where some did offset to those debts. I don't believe there's anything official out yet or anything. I didn't see anything in the news wire yet to say that there's going to be any type of systemic recovery for those. So in the meantime, you still have a client with this hardship situation and that did offset and it should not have, then absolutely TAS will work with the service to get that corrected. We have had some cases with success as far as stating that this was not supposed to occur. It did, it violated the rules, and we've been having them reversed and manual refunds issued.
That's great to hear. That's great to hear. Well, thank you for that. And so with a few minutes left, I'd like to hear from Les a little bit about a comment that he helped to write on behalf of the ABA Pro Bono Tax Clinic Committee, addressing OVRs and maybe some changes that would be helpful to see to help benefit taxpayers.
Yeah, thanks, Nancy. The ABA tax section submitted comments in, I think it was middle of January, and Nancy and a few others, Caleb were involved, and Keith Fogg, and the kind of the overview of the comment letter was, as we discussed today, there are a lot of hurdles and burdens associated with this process, and so what the comment letter focused on was, is there a way to perhaps more systematically approach this process so that rather than have the challenges that we discussed, that for certain categories maybe the OBR should be automatic, and we focused in the comment letter on three main areas, one of which is where taxpayers claim an earned income tax credit on their tax returns, and obviously the EITC is directed at low and moderate income taxpayers, and the credit has a significant impact on addressing and redressing poverty. And so the initial comment or suggestion focused around perhaps the IRS systematically, or actually requested the IRS systematically, at least for the 2020, for EITC's claimed in 2020 tax returns, the IRS not exercise its discretion to apply a EITC fueled refund to past due liabilities. The second category was, and there's some overlap, is essentially for the IRS to use its discretion to not apply refunds when taxpayers are under 250% of federal poverty guidelines. And that is a typical kind of cutoff point in many areas in the Internal Revenue Code. Obviously, as many of you know, for purpose of, let's say, defining low income taxpayers for LITC representation. So we suggested in the ABA comment letter that the IRS systematically apply its discretion and not apply refunds refunds to past due liabilities when taxpayers are at or under 250% of federal poverty guidelines. And the third area was somewhat of a different type of issue, but again, closely related. And it relates to offers in compromise. And as many of you know, on the Form 656, the IRS requires taxpayers to essentially forego the refunds in the year in which the offer is submitted, as well as when the year in which the offer is accepted. And so we suggested in the letter that in this time period, that for doubtless collectability offers, that the IRS essentially not apply its offset rights in the context of offers in compromise. So the overall thrust of the letter was trying to reflect that the process is incredibly time consuming and burdensome on both the IRS and taxpayers. And if there are categories of taxpayers who at least strongly suggest that the refunds to which they'd be entitled would have a significant impact on their financial hardship, especially in these times, that the IRS take a broader systematic approach to the issue. And as we addressed somewhat in this conversation, Congress itself is increasingly reflecting in substantive provisions, whether it be in the context of EIPs or in the context of the new kind of event, the child tax credit pilot, which is going to be kind of run in this year, that there is a need for avoiding the offset application. And so that was the you know, the recommendation, and you know, I think it makes a lot of sense, especially given how you know, how burdensome this process is, not only on taxpayers, but I think for the IRS to you know, to work through the evaluations. And so you know, we're hopeful. I think the comments make a lot of sense, and there's, you know, I think that there is some opportunity for discussion and reflection on what are the proper categories and how do you define the categories where a systematic approach should be taken. But I think the overall suggestion that the IRS take a fresh look at this and think about this from a more systematic approach really makes a lot of sense in light of some of the things we've discussed today.
Yeah, let me just jump in real quick, you guys. I think the elephant in the room in terms of the efficiency and how this works is the EIP. This economic impact payment has caused so much difficulty to the IRS, Treasury, TAS to deal with it. And so everything sort of got put to the back burner. I believe in my practice that's affected almost all of my cases. And so, you know, in terms of practical, what's happening on the street, what's happening in cases, this is an issue. I mean, even the IRS's decision in my mind to back up the filing deadline wasn't really to be kind to taxpayers. They just can't handle the volume of work of all the EIPs, of all the returns that are still waiting to be processed, paper returns from 2019. So that's also something we got to keep in mind when we're trying to advocate on behalf of clients, is that's the elephant in the room for sure.
We have a couple more minutes here. We've had some questions. I did share the comment in the chat there if anyone would like to see the tax section's comment regarding OVRs. And I think as far as some last tips, maybe just to reiterate a couple things. So number one, check with Bureau of Fiscal Service. Make sure that your client doesn't have any other outstanding debts to which the refund could be offset, because that would prevent them from being able to get the OVR. The TAS and IRS isn't going to do an OVR if they have other debt. So as Maria suggests, maybe if they can get on a payment plan or at least get out of default, then perhaps that debt can be removed from BFS's system to enable an OVR to go out. Next tip, contact TAS as soon as possible. So try to get the documents together. I think ahead of time is probably the best practice. Have the return ready to go ahead of time, and then contact TAS. But if your client did go ahead and file already, all might not be lost. It might still be good to reach out to TAS anyway, especially if it's shortly after the return was filed, or there's a delay in processing because IRS is matching income information or other information. And also try to get the hardship documents together ahead of time. And if it's going to be difficult to get the hardship documents together, consider working with your advocate or the LTA to see if they'd be willing to write a letter or a statement in support of your taxpayer getting the offset bypass refund, which in normal situations is going to be limited to the hardship documents. But from what I understand, there are situations where you might prove eligibility for the whole refund. And I think Maria outlined some of those situations, like the taxpayers living in shelter really has nothing to their name. That's a situation where you're not going to want to limit that refund. You're going to want to argue for the entire amount going to the taxpayer.
Yeah, and I think, Nancy, both Les and Maria brought this up. It's funny, that letter that I put up for you guys for that client, that was a liability on the books for her 19 year. That was an exam. That was an EITC denial. And so in the office, this is actually an opportunity for us to do a 2-for-1, right? Not only fix the liability that's occurred because of the exam, and of course she was at the shelter, and so she wasn't able to provide them with paperwork that says her kids are with her as a single mom. And so that liability from 19 is what was going to happen, was going to result in her overpayment getting taken and applied. So you're doing both. You're fixing the 19 exam with the TAS rep, and on the same case, you're basically able to have TAS help with the OVR. And we're doing that for that particular case, is we're fixing the liability. And like Les brought up, look, that liability that might be on the books might not be accurate. it's under reporting, or if it's EITC denial, or if it's child tax credit denial. So look a little closer to see if that liability that is causing the problem, that is causing the overpayment to be applied, does that have anything to be fixed? Is that a dispute possibly? Is that a correct amount of liability? Don't forget that as well. That's big. That, and by the way, they didn't know that that's going on with my client. It was just a happy circumstance, but that's exactly what's happening with her. That letter that I showed, she has a balance due, but it's because of an exam on 19, child tax credit EITC denied.
That's a great practice tip. Thank you for sharing that. Excuse me. So with that, I just want to thank our wonderful panelists for their time today. I know I've learned a lot, and I'm grateful for their time. And also thank you everyone who's joined us today for another Fireside Chat. And we look forward to seeing you next time. Thank you.